So in the interest of time and because we have an amazing program today, I just wanted to welcome everyone back after our long summer break. I hope everyone relaxed and is ready to dive back in. I'm absolutely thrilled to be here today to introduce this session and represent Marashlian and Donahue, the Comlaw Group, and Vision AI. Today's discussion is going to be on the intersection of AI and intellectual property, and it's exactly the type of forward-thinking conversations that drive our work here. I'm genuinely excited to dive into these developments with such knowledgeable co-panelists and explore what they mean for the future of AI innovation. I'm going to hand it over to Diana James and let her introduce herself, and then we'll continue from there. Thanks, everyone.
Thank you so much, Susan. Hello, everyone. My name is Diana James. I'm an attorney with Marashlian and Donahue Comlaw Group, and I assist telecom and technology companies with corporate and intellectual property matters, as well as regulatory compliance, from privacy to robocall. I'm sorry.
My name is Dave Newhoff. I'm a writer, copyright advocate for the past roughly 12 years, and consultant in that area. In 2020, I published a book about copyright and photography, and in 2021, co-founded RightsClick, which is a copyright management suite. Thank you so much for inviting me today.
Thank you.
Hi, Brian Alexander. I'm of counsel with Marashlian and Donahue, working on AI, privacy, and security law. I have a background in IP. I'm a member of the patent bar and look forward to sharing some information with you about AI technology, trade secrets, and patents.
Thank you so much, Brian. And we have a quick heads up that David has another commitment coming up after this, so he will have to leave after his section.
Thank you.
Sure. We would like to thank our sponsors too. Vision AI Plus Law Group is a practice of our firm dedicated to AI legal matters. Vision AI Plus Law Group delivers integrated legal guidance on AI compliance across governance, risk, privacy, security, and intellectual property, helping organizations align AI use with evolving laws and standards. We emphasize practical, business-aligned solutions so that companies can deploy AI ethically while minimizing regulatory and litigation risk.
Vision AI Plus Consulting Group is really the bookend to the Vision AI Plus Law Group. And we saw that companies have many needs adapting to and adopting AI. And we want to provide a full suite of services and experts to assist. So our vision is that consulting and the legal groups will provide our clients with the capabilities to navigate the shifting landscape of AI technology and risks.
Thank you. RightsClick, as I mentioned, is a copyright management suite. It was designed predominantly for the independent creator because most independent creators either don't manage their copyrights because they don't know to, they don't know how to, or they don't find the time to. And RightsClick was designed to address those issues, though it can also be used by parties like attorneys or small publishers managing rights for others. Learn more if you wish to at rightsclick.com. Thanks so much.
Thank you so much, David. So here are the matters that we'll discuss today. We'll talk about copyright ownership of AI-generated works, training data on copyright, artificial intelligence trade secrets, and patents and AI inventions. We'll also have a Q&A session at the end. Over to you, David.
Very good. Thanks so much. So copyright. What does it protect? It protects works of creative expression, and for a work to be protected, it must show what's called a modicum of originality and be fixed in a tangible medium of expression from which it can be perceived or reproduced or otherwise communicated. Of course, nobody can affirmatively define what a modicum is exactly, but suffice to say we have what the experts would call a low threshold for originality. in copyright law, that something needs to be minimally, pardon me, original in order to be protected. Although protection in the United States arises automatically once a work is fixed, we usually tell creators once you're done, that work is automatically protected. However, smart creators who are very concerned about protecting their works properly, will register their work with the Copyright Office. This avails them of important legal remedies if their work is infringed. Chief among these would be the ability to file a suit in federal court. You simply can't do it without a copyright registration. And then a timely registration, meaning prior to the work being infringed. Makes the owner eligible for statutory damages and attorney's fees if they are successful. Without the possibility of those, the likelihood that a case is even going to proceed at all is very, very low. And so it's a bit of an odd paradox in copyright law that copyright attaches automatically, yes. However, the formality of registration is still required in order to effectively enforce the rights. I will spare you the 100-plus-year-old history as to why, but that is just simply the way it is. So in thinking about AI, of course, it's important to begin with the fact that a long-standing precedent in copyright law that's really never been questioned is that humans must be the authors of works. Author is the term of art used for any kind of creator, no matter what it is, not just books. But the author must be a human. And of course, the introduction, or the explosion, I should say, of generative AI is really the first time we're seeing that principle questioned, called into question, challenged by some. But a classic example of the human authorship doctrine, at least with regard to Copyright Office internal training communication, they call it compendium. They list as an example, pardon me, a piece of driftwood, as you see in this image here, that's shaped by the ocean. It might look like sculptural work. You can think of it as a sculptural work, put it in your house if you find it beautiful. But you certainly may not send an image of this and call it your sculpture to the Copyright Office. That would be an act of fraud because you didn't make it. And you can see why this would be analogous to, say, the consideration of whether a machine like the generative AI has made a work, because no human has controlled the creative expression, that especially if you just tell the AI make something like sculptural work and it does, you've exerted no real creative control over that, and that is a barrier to copyright protection. So of course, generative AI is novel as a technology in thinking about these issues, because we've had things Photoshop around for a long time, and certainly Photoshop has been used to alter reality and whatnot. But not until recently have we had machines that can produce works that would look to any ordinary observer like a work of creative expression. However, the machine could either produce that independently and entirely on its own, or could produce it with just a few simple prompts, like make me an image of Niagara Falls, and it will do that. But that's not sufficient control. Again, that's almost the same as telling a machine, or rather just finding something that you didn't actually create. So at the moment, and I don't think this is going to change, the Copyright Office has held and courts have affirmed that works that are 100% generated by artificial intelligence, whether autonomously or in response to basic prompts, no matter how elaborate or complex the works might look, these are not protected under copyright law. To try to register that would be an act of fraud. And again, this is because of the human authorship doctrine. I don't think that doctrine is going to be overturned anytime soon, or if ever, and I certainly personally hope it never will be. However, far more complex question arises when we start to see combinations, and this is the subject of a lot of discussion, a lot of academic discussion, and also the subject of the second report of the 3 the Copyright Office has issued to date on this topic. And this is this is the question of what if a human sort of collaborates with a generative AI? So, I create some of the expression, the generative AI creates some of the expression. Where does the protection land? And the Copyright Office is open, and as are other experts, to the idea that yes, there is some protection that might live there. But it's going to be a while before we have true guidance on this, until there's more more use of it, more, and of course more litigation that will really solve or answer a lot of these questions.
Thank you, David. It does seem
Sure.
that it's a very fact-specific determination. Would you agree?
Yeah, it is. Not unlike fair use, which is your area of this conversation, but yes, it is very fact specific, and that does raise some complications from an administrative standpoint, in terms of registering works, which is kind of the subject that we're talking about in these next slides. So for example, in this next image, there it is. This is a visual work that was created by an AI called Creativity Machine, owned and designed by a computer scientist named Dr. Peter Thaler, I'm not sure. And he submitted this work for copyright registration with the office, and it was rejected. And he stated, he didn't try to fool anybody. He stated this was entirely generated by machine. He was trying to prove a point, that it should be protected. And thus far, he has lost on that argument. The Copyright Office rejected it. Dr. Thaler sued. It went up to the DC Circuit Court, and both courts have affirmed that no, human authorship is absolutely required. And they also rejected a kind of a litany of arguments he presented, that the Copyright Office invented this doctrine, it's not really in the statute. All of these arguments were effectively shut down. I won't go into all the details. The next more complicated question, though, as I mentioned, is what happens when you start to mix human expression and generative AI. And so some of you may have seen this particular one. It's made the rounds. Zarya of the Dawn is not comic book, rather a graphic novel, made by Chris Kashtanova. They wrote all the literary work in here, but used Midjourney to generate the images. And so what happened was, again, the Copyright Office said, sure, it's your literary work, but not your visual works, rejected that. Kashtanova appealed that decision, which is a long-winded and frankly, in many cases, expensive process. It's at least a few $100s. I don't remember the exact price to appeal a decision by the office, and they don't change their minds often, as I understand it. But here, what's notable, perhaps going forward, is the office it issued, I think, about a 25-page analysis as to why Chris didn't really exert enough control over the images, even though Kashtanova submitted, evidence about what they had done, how they prompted, evidence of the prompts, what their thinking was. And the office still rejected that. What they ended up doing was saying the literary work is, of course, your protection. And they gave Chris, copyright registration in what's called the selection and arrangement of all the elements. So that gives copyright protection to the work as a whole. However, if any one of the images is infringed, Kashtanova does not have protection on that individually because of that reason. What's notable, though, is that all this discussion and analysis by the office is not typical, and I'll come back to that in a moment. But before I do, going to the next image that's still in litigation, is this one by Jason Allen, who also used, I believe, Midjourney to make this image, and it won a contest out in California. I don't remember what the contest was. But in a similar way, he submitted the work for registration. It was rejected on the same basis, essentially, as Dr. Theller's. But here, Alan tries to make a case that the way in which he prompted the machine, it was really, he had a very clear concept in mind of what he wanted to make, which is key because that's what copyright is, right? It's your mental conception realized or fixed in some way. And then there's really, once it is fixed, we don't really ask how you got between here and there. It's just protected. Now with the intervention of the machine, it becomes a little more complicated. So he makes an argument that he went through a very complex prompting process and therefore did produce the images that you see before you. That is still, the Copyright Office is still standing on its position. That's currently also, I think it's in the DC Circuit at this point. He changed attorneys. I haven't looked at the most recent claims. But this will be an interesting one to watch because it really does get to the heart of what is copyright, what does it protect. But I mentioned that the office doesn't normally get involved at this level, and this is one of the tricky elements of generative AI and the Copyright Office, the registration process, because as I mentioned a moment ago, normally you present the office with a work, they are trained in looking for that modicum of originality I mentioned at the beginning. But that's it historically. They, the rest is administrative. Did you get your name right, your address, and all that stuff? But after that, it's does this work have a modicum of originality? If so, it's registered, and that's the end of the office's process there. Here now, they want to know whether or not AI was used and for applicants to limit that claim. And here it starts to get to when you look at Alan and when you look at Castanova, it's you see the office starting to engage in a process that ordinarily courts engage in. And so we're going to see some shifting in that because the guidance that the office has given thus far is a little complicated for some people, including experts in copyright law have said, it's close, but it's not quite there yet. But in a nutshell, the process is a limit of claim. And what that is historically anything that you submit to the office called your deposit copy, you have to tell the office what isn't claimed in that work. So for example, I have a nonfiction book. It contains photographs that I didn't take. And so those photographs were disclaimed in the application for the copyright. But going back to Chris Castanova's very kind of long-winded back and forth with the office, that limit of claim form is a checkbox. It's you check what you did, what you are claiming, and you check what you're disclaiming. And it's as basic as that. And in the AI space, all they're asking right now is you check other and then write in a little field that says AI. And so there's a big disconnect between how simple that is basically as a declaration versus the kind of analysis that was done in Chris Castanova's place. The other sort of complicated conversation that's being had and going to continue is the distinction between generative AI and assistive AI. Now, in the Copyright Office's report on this topic, it stated essentially that assistive AI should certainly not be a basis for invalidating or rejecting a claim of copyright. Think of assisted, we mentioned Photoshop a minute ago. Photoshop has always had certain tools in it that will do certain things automatically for the creator, and that's never really been an issue. Likewise, you might have, everybody's got, grammar checking tools in their word processing program. Like them, hate them. Those are being enhanced with AI for better or worse. But that wouldn't necessarily be considered the same thing as the AI generating the expression. But that doesn't mean that some creators won't be somewhat confused when it comes to how to claim or not claim AI use. And it's not going to be the same for every type of work. A writer creating a literary work using grammar check, that might be obvious. But when you start to get into, say, visual works and where the AI played a role, it may be a little gray for a lot of creators. So, I don't have clear answers on that, and certainly I couldn't generalize about all works in that regard. But that will be one of the challenges going forward.
Well, that's wonderful, David. Thank you so much for a very insightful presentation. The discussion of assistive versus generative AI is super interesting and very relevant to the fair use discussion on the transformativeness of the use. But I just wanted to thank you so much for joining us today. I know that that you have another commitment coming up. So we appreciate you coming. We urge our viewers to connect with David, and we'll have the contact information up during the Q&A session. Thank you, David. See
Thank
you.
you. I'm sorry I
Thanks,
have to go.
David.
Thank you so much.
Thanks, David. Really interesting.
Thanks.
Thank you. So now that David has outlined the types of works protected by copyright, I'd like to quickly remind everybody what rights copyright confers on the copyright owners. Here we are. Yep. So copyright grants its holders an exclusive right to use the works in ways listed in Section 106 of the Copyright Act, which include making copies of the work, distributing the copies of the work, and creating derivative works. These are the types of use that are relevant to our discussion today with regard to AI. Exclusive rights mean that only the copyright owners have these rights outright, and everybody else would have to license the works to use them for the same purposes, to create copies, make derivative works, etc. This is important for our conversation today because we'll be talking about the copyright copyright infringement cases concerning training AI on copyrighted works. And in those lawsuits, copyright owners allege that AI companies made unauthorized copies of their works to train their AI, among other legal theories. So I wanted to share with you the first screenshot here. It is by a computer programmer who wrote code, including some code subject to open source licenses, at least one of which required that any use of the code that he developed is then only used for free games, and anybody who uses the code attributes in their resulting code, if they make some changes to it, for example, for their own purposes, that they attribute the creator of this code. And this screenshot was featured in a complaint against GitHub that was filed by computer programmers who wrote code and posted it on the GitHub repositories. And these programmers claimed that this code was then licensed to Microsoft to train the models that were used to create their Copilot tool. And in this tweet, one of the programmers claims that the code that he wrote and posted on GitHub repositories was then used by Copilot because he sees that as a part of the output that he received using Copilot. And the second image that you can see on the screen is an output that I got when testing a popular image generating AI about 2 years ago. I was curious how it would react to a simple textual prompt, Afghan girl, which in many of our minds will bring up a memory of a famous photograph that you can see on the screen as well. And apparently it also came up in the mind of the popular image generating AI. So there seems to be evidence that generative AI has been trained on copyrighted works. And That is important for our discussion. However, as you are likely aware, there may be a way for unauthorized copying to be excusable under the fair use doctrine. And this is what we will talk about today. First of all, let's discuss what it is. Trying to balance the interests of copyright holders and the public, Congress has codified the fair use doctrine, which before then existed in common law for a long time. But under this principle, under this doctrine, copyright infringement is sometimes excusable for purposes like criticism, comment, news reporting, teaching, scholarship, and research. Congress also codified the criteria courts must consider when they decide whether the use is fair in each individual case. And these criteria are the purpose and character of the use. For machine learning, two examples are relevant. The first one being, is the use transformative? Meaning, does it have a different purpose or character than the character and purpose of the original work that is being used? Secondly, is the use commercial? Transformative use weighs in favor of fair use, but commercial use weighs against it. Nonetheless, courts tend to give more weight to transformative use, even if it is commercial. So this is still a novel question in copyright, so we don't have clear guidance from the courts on this, on the matter of transformativeness of machine learning on copyrighted content. But the Copyright Office argued in its report on copyright and AI, third part pre-publication, that some machine learning uses may be more transformative than others. And this is relevant to the assistive versus generative AI tools. For example, compare training AI on books, on the one hand, to create a grammar assistant, and on the other hand, to create a service that generates text in response to user prompts, resulting in what could have been called as expressive works that may compete with the books on which it was trained. So the courts will take into account the type of use, the ultimate purpose of the AI tool that is trained on on copyrighted works when determining whether the use is transformative. Moving on, the second and third fair use criteria may be less consequential than the first and the fourth one, so I won't expand on them, but they are the nature of the work, meaning is it a very creative work or not so, and the amount and substantiality of the portion of the work used. Finally, the fourth factor is highly relevant for machine learning for the fair use analysis, and it is the effect of the use upon the potential market for or value of the copyrighted work. If there is a negative effect, this factor weighs against fair use. In many copyright infringement cases involving AI training on copyrighted works, authors have argued that the existence of generative AI significantly reduces the demand for their work. But they may or may not have been successful in proving that to the court. So let's discuss the cases that we already have on this. Although this is not case law yet, we do finally have two district court rulings on generative AI training and fair use. Both of them concerned training LLMs on copyrighted books without the copyright owner's consent or compensation. In the Kadri versus Meta Platforms case, the district court held that Meta's AI training on books was fair use. In that case, Meta trained its Llama LLM on pirated books. The district court found that the copying was highly transformative because Meta copied books to train its LLMs, which are innovative tools. The judge, however, noted that Under the fair use doctrine, harm to the market for their copyrighted work is more important than the transformative purpose for which the copies are made. And the judge mentioned that plaintiffs could have succeeded in this case. The authors could have prevailed if they had built a better argument that Meta's use would likely flood the market with similar works, leading to market dilution. So that didn't happen. And the second case that we have the ruling for today, Barthes versus Anthropic. Anthropic created an internal library of consisting of over 7 million pirated digital copies of books and millions of paper books it purchased legally and scanned. So it was a mixed library, so to say. Anthropic then used the library to train its LLMs, including those used in Claude. Then Anthropic kept this library, potentially for other uses and purposes. And these are the facts that were established in the case, in the discovery. In this case, the district court found that training models that were used to create Claude on copyrighted books was a transformative fair use, but keeping a library containing pirated books so that portion of the case is going to try. Parties $1.5 billion preliminary settlement, which according to the plaintiffs would result in authors receiving $3,000 per infringed work. However, on Sunday, Judge Alsop refused to accept this preliminary settlement until the parties finalized the details, such as the list of the works that were infringed. So what we know for sure right now is that only books with registered copyrights at the relevant time can join the list. So these are just the two first cases on generative AI trained on copyrighted books, and they don't set a definitive precedent yet because they're not binding on other courts. They're just district court rulings right now. And we know that there are over 50 other cases pending on similar on the similar matter. Now, there may be some future lawsuits, potentially with different evidence and legal theories, resulting in different outcomes. Appeals are also possible, and higher courts may revisit or overturn these district court decisions. And finally, Congress may legislate this matter once and for all. So we will see how this gets resolved. Over to you, Brian.
Great. Thank you very much, Diane. I appreciate it. So I'm going to start by talking about trade secrets a bit. And the image here is of the vault in Louisville, Kentucky, where Colonel Sanders' original handwritten recipe for Kentucky Fried Chicken is securely kept. I'm going to discuss protecting competitive advantage using AI, using trade secrets, and the flip side, which is the loss of trade secret protection due to the use of AI, and especially generative AI. Many technology companies publish papers on the doing back in 2017. Paper mechanism, and that concept and the concept that was disclosed in that paper is really fundamental to all of these current LLMs. And other tech companies, of course, are also publishing a no secret, that trade secret, can't publicly disclose it. But sometimes they may release papers to create roadblocks to patents on technology, or there are many other reasons. But the companies building these models, they keep their secret sauce. That is their competitive advantage out of the public view. And really at its core, AI is software and data. So source code and data are prime areas where for trade secret protection. One point to be made is that many of the coders have a preference for open source, and some are philosophically opposed to traditional IP protections. I don't want to overgeneralize, but so that can create a tension. And the use of AI coding tools, generative AI coding tools, which are generally trained on GitHub, that's exacerbated the issue. Add agile development processes in, and it can be difficult to manage source code IP. And, of course, most companies are not developing foundation LLMs, but many are developing AI for internal use, or they're embedding AI in their products. Companies are also working with AI developers using their company data to train ML models, or to augment an LLM, or they're providing feedback loop on model tuning and post-deployment monitoring. So let's talk briefly about the basics of trade secrets. Versions of the Uniform Trade Secrets Act have been adopted in 49 states and the District of Columbia. The Virginia Trade Secrets Act is Title 59.1, Chapter 26, for those here in Virginia. Where there's misappropriation of a trade secret, the UTSA, or Uniform Trade Secrets Act, provides for injunctive relief, monetary damages, and attorney's fees. And also there are protections from disclosures to tribunals and government. And we'll see in other laws also protections for trade secrets, like the Colorado AI Act, which I'll talk about in a moment. But the UTSA also has other protections for holders of trade secrets. And so let's talk about what is a trade secret. A trade secret means or is information including, but not limited to, a formula, pattern, compilation, program, device, method, technology, or process. And the key is that it derives economic value from not being generally known or readily ascertainable by proper means by others who can use that information to gain their own economic value from disclosing it or using it. And the second prong of that is that the trade secret must be subject to efforts that are reasonable under the circumstances to maintain its secrecy. And that's, fundamental to trade secrets. Now, the Federal Defend Trade Secrets Act applies to misappropriation of trade secrets used in interstate or foreign commerce, and that opens up actions in the federal courts to where there's theft of trade secrets. And I won't go into the details. There are some differences. DTSA allows for ex parte seizure of property to prevent dissemination, and there's some other differences. But the key is that they go hand in hand. The DTSA, Defend Trade Secrets Act, does not preempt these state laws on trade secrets. And I mentioned before that other laws also provide protections of trade secrets. The Colorado AI Act is one example. And by the way, there are efforts to delay the effective date of that next year. So stay tuned for that. But the Colorado AI Act requires AI developers to disclose certain information to AI buyers and users, and to the Attorney General of the state. But it specifically accepts trade secrets if they fit in the definition of under the Colorado UTSA. So there's other laws that are like that as well. So let's talk about AI assets that may be trade secrets. If a company is using AI for its business, there may be AI-related assets that can be or should be protected as trade secrets. And if you think about your data first, if you have proprietary data sets, you may already be protecting them as trade secrets. If you're data can be used or is being used to train or augment an AI model, then it'll have increased value, and you might need additional protections to keep that trade secret status. Techniques for data labeling, annotation, extracting data from workflows, data cleaning and management tools, all of these may be trade secrets. Synthetic data that your company uses, or the different methods or processes that you have to create that. And I'll talk about production data in a moment, but in model development, there are areas to consider. If you're developing AI or if you're working with a developer to customize an AI solution, the custom system architecture, hyperparameter tuning strategies, model tuning data can be really valuable, because if you have the model tuning data and you have the trained model, you can get insights on the training data, and you can maybe even extract that data out. So also applying edge AI, logic, decision-making process, guardrails, or other controls you put in place for AI, all of these should be considered. And then, excuse me, if you consider the production data as at the system input side, you know, any company data or other data that's collected or aggregated or transformed for production purposes should be considered for trade secret purposes. And other inputs like prompt engineering may also be protected. We'll see also that's important in the patent space as well. So for many organizations, the outputs of AI are the key. That's the information that really provides key competitive advantages and should be protected. So, you know, think about recommendation algorithms and personalization parameters, heuristics identified via AI tools like in fraud detection, customized ranking and rating systems, all of these things. So I'm not going to review all the cases. So you went to the next slide, which I'm about to jump to anyways. But I'm not going to review those cases, but they're the movement of employees and people between tech companies obviously has created a lot of litigation in that space of theft of trade secrets. So Gen AI also pose a particular risk to trade secret protections. Employees may use Gen AI and think that it's completely secure. And we've seen many cases of employees inputting trade secrets or other confidential information, including confidential source code, into generative AI systems, and that don't really have protections for the user, data protections. So users need to be made aware that entering trade secret or any confidential information in Gen AI prompt may be a public disclosure, and that they may not be able to delete that data that they enter into the system. So how can your company mitigate the risks, not just of disclosure, but generally to protect trade secrets? Implement policies, communicate and enforce them, perform due diligence on AI systems and vendors, review the vendors' privacy policies and terms and conditions, ensure contractual agreements include confidentiality provisions, and reinforce security requirements with management, employees, vendors. Internal AI tools such as enterprise solutions from trusted vendors, and implement technical safeguards like data exfiltration monitoring. All right, so moving on to the next, and patents could of course be their own course, but we, next slide, please.
Could I please also add, a lot of these services are something that we can help with, developing all the policies and doing audits and reviewing contracts. But back to you.
Thank you, Diana. Thank you. So we'll start by discussing whether AI can be an inventor. Then we'll turn to a discussion of patenting AI inventions. And so Thaler v. Vidal is involved. This is the same Dr. Thaler, by the way, that's in the copyright case, and he was a plaintiff in that's the Perlmutter case, I think. In this case, Dr. Thaler claimed that an AI system he developed called DABUS, he had created two new inventions. His AI invention had created two new inventions a food container that had a fractal profile, making it easier to grip and stack and providing improved transfer. And then a flattening beacon for emergencies, improvement old version. It was called the neural flame, excuse me, neural flame. But individual who invented or discovered the subject matter of the invention. Individual is not defined anywhere in the Patent Act. So Dr. Thaler was saying his DABUS system qualified as an individual and therefore could be a patent holder or an inventor under the patent laws. And the Court of Appeals for the Federal Circuit disagreed with Dr. Thaler, and the Supreme Court denied cert on this case. So it's really settled that inventors included in a patent application, they must be human beings. But AI-assisted inventions are not categorically unpatentable, and we'll see there's these parallels with the copyright space as well. And AI tools are obviously being used in the inventive process all over the place. So last year, the USPTO provided some guidance based on the court decisions, the law, and some of their past guidance. And it makes it clear that a natural person, if a natural person makes a significant contribution to an AI-assisted invention, then it may still be patentable. And whether there's a significant contribution that by the human, that's not a bright line test. The USPTO has provided some guidance, and I won't go through all of it. I'll just talk about one of them. Let me see here. A natural person who presents a problem to an AI system may not be a proper inventor, but the person could provide significant contribution if they construct the prompt in view of a specific problem to elicit a particular solution from the AI system. And so that's sort of gives you the theme. Just recognizing the output of an AI system is not enough to be an inventor. But if you take that output and you make a significant contribution to create an invention, then you may be an inventor, it may be patentable. Okay, next slide. So there are foundational patents. The figure there, those are some figures from a patent claiming tokenization, and I'll spare you from looking at the claim language. But in recentive analytics, the Federal Circuit affirmed the lower court's dismissal of a patent infringement lawsuit. And in this case, they held that the plaintiff's machine learning patents were ineligible for protection because they were directed to an abstract idea and did not disclose a specific technological improvement. So simply applying generic ML technologies to optimize a television schedule, in this case, it was television schedules. So to optimize television schedules in this case, that was insufficient to transform an abstract idea into a patent eligible invention. The elements for patentability, they're on the screen there. And I'm just going to talk a little bit about a couple of them here. Really eligible subject matter for a patent, because that's so key to this. It must be a process, machine, manufacturer, composition of matter under the Patent Act. And AI is essentially treated the same as software. So the focus is on the invention, not the tool. But a patent claim cannot be directed to abstract ideas, natural phenomena, or laws of nature. So the USPTO, going back to their guidance, they have a number of illustrative examples, and they draw that distinction between patentable and unpatentable claims that include AI. And essentially, and I'm boiling this down a bit, AI inventions may be patentable if they do not recite an abstract idea or a mathematical concept. And there is a whole test, whether there is Alice test is part of a whole line of cases where they analyze these, and I won't go into the details of that. But if AI is used to improve an existing technology, then it may be patentable. So utility, novelty, and inventiveness or non-obviousness. There must be real world use. The invention claim must be new, not previously described in the prior art. These are, sort of treated in the same way. There are some twists to it for inventiveness and non-obviousness. To be patentable, an invention can't be obvious to a person of ordinary skill in the art, in the relevant field at the time the invention was made. And so one issue with AI is you've got this rapid pace of new invention, especially with AI assisted invention. So what is known and obvious to a person that's skilled in the art is really rapidly changing. And this results in a shift in what's novel and what's inventive. And the last thing I'll mention, then we'll move on, is there's also an enablement or disclosure and disclosure requirements in patent applications. They must include a clear and complete description of the invention. And this comes up with respect to patent practitioners and their duties as members of the patent bar. There's a duty to disclose. And so, this is an example actually given by the USPTO, where an additional embodiment of an invention is disclosed in the specification of the patent, and it was developed by an AI, where you have the AI creating a patent application and it creates a new embodiment of an invention. And so the AI system is the one that created that, not a human inventor, and that would create an issue then. So, and I'll stop there.
Thank you, Brian.
I have some cases. There are a number of cases on patent infringement and AI technology. I'm not going to talk about those, but just to show you all the big players involved with their stacks of different patents. So thank you, Diana.
Thank you so much, Brian, for a very concise and informative intro to such a huge field. I don't know how you did it. We have another webinar coming up. Brian, would you like to introduce it?
Yeah, absolutely. We hope you could join us for our next AI masterclass on September 23rd. And here we'll talk about the intersection of AI and security, securing AI.
Thank you. So now we're opening up the floor for Q&A. Please write your questions in the chat. I see we already have some questions. Yesterday's presentation was about US law.
I will say, across the globe, there are these same questions are being asked, like, in patent law, can an AI invent? That same question is being asked. The UK and EU have decided on that. And in copyright, it's the same. It's kind of analysis going on country by country.
As for Me's question about the Anthropic legal settlement, whether it is good or not good for the industry, depends on which side you're looking from. As for the tech industry, the ruling on fair use was already in favor of Anthropic. The judge found that training AI, training LLMs that were used to create Claude were fair use, even if it was done on pirated works. However, the settlement concerned the fact that Anthropic kept the library. It created a library of all the works it could find, all the books it could find, including those that were pirated. So far, this case has already been in favor of the AI industry. So we'll see how the rest go.
And it may be added to, for users, a lot of them don't really notice some of that, but some, they want clarity, they want to de-risk themselves. So
absolutely. And Me, you had another question about AI tool licenses. Could you please paraphrase it? And we can address some other questions in the meantime. So, Jamie, is saying specifically looking at this AI music company that owns the source music that the LLM is trained on and keeps the license but provides use rights for users making AI music with it. Could you please paraphrase your question? Okay, Jamie's asking, how is the license of AI material possible with this company? So I can't speak to the particular company in particular case because I'm not sure of all the circumstances there. It is possible to license material to train AI on it, and that is actually the goal of a lot of the data owners, such as copyright owners and subjects of personal data, for example. That is what they're trying to have happen, because in a lot of these lawsuits, data was obtained without the either data subjects, if we're talking about personal data, or copyright owners' knowledge or consent or compensation. But we see that big AI companies are already entering into licensing agreements with very significant copyright owners and managers, for example. Me is asking, do licenses protect the data, or should all proprietary data be considered at risk? A free version of a chatbot compared to a business license? If this question concerns trade secrets, does this question concern trade secrets and entering data in public-facing AI interfaces? Or okay, yes. Brian, would you like to answer that?
Okay, so I see, do licenses protect the data? I mean, certainly, you can have agreements and should have agreements protecting your data and also other security controls around your data. And I mean, if it's in the trade secrets context, that's, reasonable measures to protect are required to maintain that trade secret status. So, anytime that data is being used or for whatever reason, it needs to be controlled in that manner. But, I mean, as far as, you said here, or should all proprietary data be considered at risk? And, I mean, absolutely, it needs to be, there's risks with this data, and anytime that access is provided to a system or to individuals, then there's risks associated with that. So most certainly that needs to be addressed by companies, and regardless of whether they're trade secrets or anything else, if it's confidential information of the company in any way. So, and yeah, repository. So, okay, so
Thank you. We have some time for some last questions here. But in the meantime, we would like to thank everybody for coming, for your insightful questions, for your attention, and we urge you to connect with the speakers. We're happy to connect on LinkedIn. Please shoot us emails. Happy to continue this discussion.
And hope to see you in 2 weeks at our next
Absolutely.
AI Masterclass. Very good. Thanks,
Thank
Diana.
you. Take care.